Good afternoon, and thank you for joining us for the program Certificate of Deposit Programs and Broker Deposits. My name is Matt Bisanz, and I'm a bank regulatory lawyer in Mayor Brown's Washington, D.C. office. But before we get started, a few housekeeping items. We are offering CLE credit to those seeking it for today's session, and we'll read the CLE code aloud when it appears throughout the presentation. The CLE forms have been circulated along with the connection details for the session, and they should be completed and returned to the Mayor Brown email address listed in the documents. Should you have any questions throughout the presentation, feel free to enter them into our chat box and we will do our best to answer. Finally, please note that we will circulate a copy of the materials and a replay of this session in the coming days. And with that, Brad will start us off.
Thanks, Matt. And I'm Brad Berman. I'm counsel here in the New York office in the Capital Markets Department. Next slide, please. And thanks again for joining us. Next slide. So certificate of deposit programs, we see a very wide variety. You have what we call plain vanilla, fixed rate, floating rate. This is much like your grandmother's or great grandmother's traditional CD, but it's held through a brokerage account. Structured or market linked CDs, they reference the performance of an underlying asset. And then we have what we call lightly structured, which might just be fixed to floating rate CDs, step up callable CDs. Next slide, please. So structured CDs, these are CDs that the performance is referenced to reference assets very similar to those you see in a registered structured note program, ETFs, indices, single stocks, currencies, rates. Because these are not registered, you have a little more ability to link to some assets that you couldn't do in a registered program. Particularly the SEC has what they call the Morgan Stanley letter, which is about the amount of public disclosure about the underlier that doesn't apply. So you could link the small cap stocks, non-US stocks not registered in the US, credit link instruments. Of course, the sales and the investor suitability is always a consideration, whether or not it's a registered security or a CD. We see interest bearing or non-interest bearing and fixed, floating, or indexed interest payments. Next slide, please. Other features, callable versus non-callable. There could be leverage, upside and downside. You could have greater than, equal to, or less than any increase in the performance of the underlying asset. A survivor's option, also known as the death put. Upon the death or incompetency of the investor, the estate can obtain the deposit amount prior to maturity. This is something we see with some lightly structured notes. There's kind of a window because there are sort of these shady characters around who abuse this. Unfortunately, they're generally attorneys. So a lot of banks, and you see this in notes too, there's kind of a window of aggregate principal amount that will allow this for 1 year. Once the window shuts, you can't do any more in that calendar year. The big difference from structured notes is you cannot pay less than principal on a CD at maturity. So there's no non-principal protected market link CDs. Otherwise, the FDIC would take the position these weren't deposits and not subject to FDIC insurance. However, if you were to sell them prior to maturity, you probably would have to sell them for less than the principal amount, even if selling back to the bank. And the principal protection applies only at maturity. Next slide, please. So, and this is going to be a theme that goes through almost all the materials I'll be covering, is kind of what are these things? Well, what are the securities laws consideration? If you look at the Security Act of 1933, the definition of security has the phrase certificate of deposit. However, under the relevant case law, and the key case is a Supreme Court case, Marine Bank versus Weaver, they said there that the Supremes said the FDIC insured CDs are typically not treated as a security. Why is that? Well, guaranteed payment of principal, like that's what I said in the previous slide, you can't pay less. There's a whole regulatory scheme over banks already. There's banking regulations, there's the FDIC, so there's a lot of protection there. And it's very similar to the concept for national banks of an exemption from OCC registration. So But can a CD become a security? Well, if you have bad enough facts, yes. And the key case there was called Gary Plastics. There you had a broker marketed CDs that it obtained from other banks. The broker promised to maintain a secondary market in order to guarantee liquidity. So there was this kind of a promise of a secondary market almost used in marketing the CDs that caused a problem. And the broker represented to investors that had reviewed the financial soundness of the issuing banks. So you get those facts together and the court said, hey, this looks more like a security than a banking product, and it got treated as security. Now, about 4 years ago, there was another case. Essentially, a broker dealer was churning structured products and structured CDs in order to get fees. And essentially there was a footnote, it was an SEC action against the broker dealer. And the footnote there said, you know, they cited Gary Plastics and they said, we're going to treat these CDs as securities. So if there's bad behavior, that can result in a regulator saying it's a security, not a CD. Next slide, please. So consequently, our secure structured CD offering documents are drafted with these concerns in mind. In particular, in the secondary market disclosure, it always says the broker may maintain a secondary market, but they're not obligated to. So what about state? Now, we've talked about the federal, the Securities Act of 33 and the Supreme Court. Well, what about the states? There's 50 different little mini SECs. Obviously, they're not bound to follow Marine Bank versus Weaver. Well, generally, the state blue sky laws don't apply. Even if it did apply, the CDs could be, you would say, well, they're 3A2 securities, which are covered securities with respect to which the states can't require registration or review any documents. So that's how the state security angle is treated. Next slide, please. Oh, that's time to hand it over to Matt for the next slide.
Yeah, so as Brad was saying, that one of the reasons why these products get such favorable treatment under the securities laws is because they are a banking product. They are subject to regulation by the FDIC. And that's one of the other reasons why they are so loved by customers, is that they can, in many cases, obtain deposit insurance, which protects the customer not only from not from market loss, but from the loss by the bank. And so, even though it's principal protected by its terms to be a deposit, there's also the deposit insurance that is a form of, I'd say, credit risk protection from the FDIC. So that's why these products offer so many benefits. And currently, the limit on FDIC deposit insurance for CDs and other bank accounts is $250,000 per depositor per ownership category. And so what that means is that if I open an account at Bank A and an account at Bank B, each of those accounts gets $250,000 of deposit insurance. I can effectively cover up to $500,000 across those two banks. If I open two accounts at the same bank, two plain old accounts in my name, I still would only get a total of $250,000 at that bank because I'm one depositor at that bank. But the FDIC also has this nice concept called ownership categories, where if I open an account at the bank, my relationship in that ownership category gets $250,000. And then if Brad and I open a joint account at the bank, then I get another $250,000 because my joint account with Brad is a different ownership category. This tends not to affect CDs too much for the reasons we'll cover in some of the later slides, but it is something to bear in mind when you're structuring different types of deposit programs, when you're trying to exclude certain items for aggregation purposes. The other item I'll mention is that the deposit must be issued by an insured bank. That we do CD programs for insured banks, and also in the U.S. there are U.S. branches of foreign banks. So a Canadian or a French bank might open a branch in New York, and those branches are not insured by the FDIC. They are still generally treated as banking organizations, and so they may be able to issue uninsured CDs. These uninsured CDs obviously would not benefit from FDIC insurance, but if you are the type of person who doesn't care about FDIC insurance, maybe you're an institutional, a corporate doing cash management, then that type of uninsured deposit through a branch is still something that you would be interested in. Now, stepping back to the deposit insurance rules, the application of them will vary depending on the type of the investment account. There's extensive guidance available on the FDIC's website. Typically, deposit insurance is assessed retrospectively, so it's not as if you can go and get the FDIC to bless it of, well, my coverage would be X number, $1,000 across these banks. That is only if a bank were to fail, would the FDIC process the claims and apply the deposit insurance coverage. We haven't had a bank failure in, I think, 2 years now. So that, again, back in 2008, much bigger deal. Today, this type of application of the claims rules is less important. Now, as Brad said, that a bank cannot do principal reduction, and even if a bank issues an appropriate insured deposit, not all payments are guaranteed. That principal and accrued interest payments are covered by FDIC insurance. The FDIC has argued that contingent payments at maturity and any indexed interest payments are not insured until determined. So if a bank were to fail before a determination date for an interest payment, even if part of that period for the determination period had elapsed, the payment wouldn't be covered by FDIC insurance. And this is only accrued interest payments, things that the bank is actually booked as accruing to, or that the person is legally entitled to as accruing to them. Only those interest payments are covered by FDIC insurance. FDIC insurance also will not cover any amount that's paid in excess of principal, such as a premium in the secondary market transaction. This can be if a investor is buying a CD at above face value, maybe because it pays an above market interest rate. Less common right now with the increases in interest rates. Maybe a couple of years ago, this would have been more common. But if they do pay above face value, that additional amount is not insured. However, the FDIC insurance will cover the accrued portion of an original issue discount because that is the face amount that has been to date under the time value of money. And so if an investor bought a CD, a zero interest, let's say CD for $900, that they would receive $1,000 in 3 years. Well, after 1 year, the bank fails, the investor is going to get back their $900 that they paid plus the $33 of original issue discount that they would be entitled to receive, because that's what had accrued over the first year of the CD. Slide. Yeah, one issue that has been becoming more frequent for Brad and I over the past few years in structuring these programs is the way that FDIC insurance coverage and record keeping requirements are handled. And back in the old days, it was easy because the CDs were actually issued on a certificate, and you could put all sorts of monikers and restrictive language on them. But now it's done electronically through things like DTCC and through broker dealers. And so the nature of the record keeping is a little harder to conceptualize. But the current approach is that deposit account records for CDs do not need to disclose the name of the beneficial owner because they're held through an intermediary. And under the pass-through deposit insurance rules, the FDIC will allow deposit insurance to pass through to the beneficial owner if the bank has some record showing that there is a pass-through relationship. This can be highly prescriptive, but it also can be beneficial in that the bank does not need to be constantly updated within, say, a retail CD program, the millions of people who are buying and selling these deposits through their broker dealers, that those broker dealers don't need to constantly give the names to the bank. And so this saves a lot on the bank record keeping side. Also, with respect to negotiable CDs, banks do not need to retain any beneficial ownership information because the negotiable CD can always be negotiated to a new person without any obligation to update the bank. But if the bank were to fail, the current holder, the person seeking to redeem the CD, would need to prove to the FDIC that they acquired the CD prior to the bank's failure. And that's because we're again looking at, was the person a depositor of the bank at the time the bank failed? And so if the person had negotiated and acquired the CD prior to failure, then they would be able to show that they were a depositor at the time of the bank's failure. Now, these rules for things like pass-through deposit insurance and negotiable CDs, they are not ownership categories. They are rules for applying the deposit insurance provisions, but they're not themselves categories. And so if I were to purchase a negotiable CD in my own name as a single account holder, and then I had a checking account at the bank, well, those two would be combined for calculating the $250,000 limit. The fact that one of them is held indirectly through a broker dealer, or one of them is held through a negotiable CD, and the other is a direct relationship with the bank, that doesn't matter. I can't get additional insurance coverage now. Slide. Now, from a bank-centric perspective, which I think some of the people on this call will have here, there are extensive record-keeping requirements that you comply with for all deposits. And applying those requirements to brokered deposits or CDs, brokered CDs can be a little complicated because, as I just said on the prior slide, you don't have all the information that the broker dealer, DTCC, has that information. They're not going to give it to you. And so in some cases, you will need to enter into agreements with them to obtain that information if you were to fail. In other cases, you may offer to enter into those agreements, or you may offer to test your systems to say, look, if we were to fail, would you be able to provide us with the information on these customers so that they could obtain a payout from the FDIC? Some broker dealers will want to do that. Some won't want to do that. And a lot of this is handled behind the scenes by the banks and the FDIC. And it'll vary from bank to bank. And so that's often a point of discussion when negotiating these agreements. Slide. For the largest banks, these are quite complicated rules. And again, nothing requires the bank to possess the name of the beneficial owner. Most banks don't. But your IT system does need to be fairly sophisticated. So again, changing from the world of paper certificates of deposit to an IT system that can upload information from a broker dealer, that's been a sea change over the last 5 years. Slide. Now, to turn briefly to one more, next slide. One item, since we're talking about negotiating the brokerage agreements from a bank perspective, there is one bank requirement that I included because it's something that is in almost every brokerage CD, every structured CD product I see, but it really ends up not being particularly relevant. And that's the Truth in Savings Act as implemented by the CFPB's Regulation DD. It's applicable to issuing banks and to the deposit broker, so the broker dealer, the other person who's intermediating the CD. And it's a prohibition against advertising deposits in a way that's inaccurate or misleading. So it requires certain disclosures of the APY and penalty fees and other types of fees. And it's akin to an anti-fraud statute, but it's included, and typically the bank will require the broker to comply with it as a condition of intermediating the CDs. And so the broker will say that I agree to comply with the anti-deception and accuracy provisions of Regulation DD as a condition of selling your CDs. And that's a typical provision. And again, there's always the horror stories like what Brad was describing with some of the Gary Plastics cases, but for most broker dealers, this isn't too difficult to comply with. There's also the fact that beyond Regulation DD, when you're dealing with a retail product like this, there is the FTC Act, which prohibits unfair or deceptive acts or practices. It applies to everything a bank does in the consumer products and services sector. It's enforced by the banking regulators. And so even to the extent that there isn't language in an agreement or it isn't covered by Regulation DD, the UDAP provisions of the FTC Act are something that keeps banks on their toes as they have to make sure that they know how this product is being offered by the broker dealer, and that like there typically will be provisions around, well, the right to review advertising materials, the right to provide advertising materials, minimum disclosures. Most of these are fairly standardized, but this is the kind of penalties that they are those standardized disclosures are protecting against. And with that, I will turn things back over to Brad, I think.
Thanks, Matt. Next slide, please. So Matt had mentioned that sometimes U.S. branches of non-U.S. banks issue CDs, and these are known as Yankee CDs. So they don't have the benefit of FDIC insurance, but they're designed to have the preferences for deposits that apply under applicable banking laws. So the question is always, is it a bank product or is it a security? Remember, Marine Bank versus Weaver was all about having FDIC insurance. So we remove that. You have to start looking at their characteristics. So you look at the instrument, how it's marketed. The OCC had said in 1994 it didn't intend for the definition of security to cover deposits or traditional bank products. So the questions we ask when clients ask us this question, are they transferable? How does the issuer record them on its books and records? Is it recorded as a deposit or a security? I mean, generally they're recorded as deposits. Even if there's concern about there being securities, an exemption from SEC registration can typically be found if it's a federal bank branch under the OCC regs as part 16.6. These are typically offered in large denominations, privately negotiated transaction with sophisticated investors. And the disclosure is important. You want to consider what to disclose about the issuer, the instrument, and the risk factors. Now, when you take, like in a typical CD offering deposit, FDIC insured bank, there's a big section about FDIC insurance, and that really covers the situation of the bank going belly up. When you have a Yankee CD, you really have to disclose what would happen if the branch went bankrupt, because you don't have the FDIC coming in making people whole. So those are the sort of risk factors and disclosures you want to make sure are in Yankee CDs offering documents. Next slide, please. So what is FINRA? How does FINRA approach CDs? Well, because they're usually not securities, there's a lot of rules that technically don't apply, like the corporate finance rules. But for structured CDs, most broker dealers apply a comparable degree of compliance and sales procedures as they do in the case of structured notes. They're not going to treat investors any less just because the wrapper is a different form. Some key areas of FINRA regulation that you do have to be concerned about: structured CDs, retail communications, things should be fair and balanced. Communications by broker dealers should be fair and balanced and accurate. FINRA has made some substantive comment to broker dealer marketing materials for structured CDs. Training and new product approvals should be treated by the dealer the same as structured notes. There's people selling it should understand, what they're selling, and there should be a new product approval process, much like structured notes, making sure who's going to buy this, what the risks are, what's the target target investing audience. Next slide, please. And then third-party distribution in the same way in a registered structured notes program where you'd have an issuer and its affiliated broker-dealer being the first step, and that affiliated broker-dealer sells downstream to others. Structured CDs are typically distributed the same way. A bank would many times have an affiliated broker-dealer that's going to have the equivalent of a distribution agreement with the bank, and then they'll have a MISDA or master select, sort of a selected dealer agreement to sell downstream. So you've got your dealer that's in privity with the bank selling downstream. You need a separate agreement for this. It's different from your SIFMA form because it's a whole different regulatory regime. As Matt mentioned, there's FDIC record keeping requirements. You need to have reps that the bank's keeping, doing that. You want to make sure the distributor's selling certificates only to retail investors. All communications about the CDs that the bank produces will actually be delivered to holders. You don't want downstream dealers creating their own offering materials that might say something wrong, and acknowledges that holders might enforce their rights directly against the bank. And again, the background concern is that if you have a downstream distributor doing something bad, a la Gary Plastics, all of a sudden, beside reputational risk, suddenly someone comes back and makes an argument to a regulator, well, they really sold me a security. Let's get the good old securities laws against these guys. And there's, a number of negotiated reps and warranties, usually for the benefit of the distributor. Next slide, please. Finra's proceedings and any of these structured products, basically liabilities on the responsible entity. In other words, the cases aren't about bad disclosure where you would go back to the bank. It's usually in the case of bad sales practices. And also we go back to Finra's 2013 conflicts of interest report that recommended know your dealer diligence procedures. So banks and their affiliated broker dealers should do diligence on the downstream dealers in the same way they do in any registered or exempt structured products program. Next slide, please. So what type of disclosure documents do we have? Well, unlike a registered program, we have Form S3 and Reg SK telling you exactly what to put in there. There are no specific form requirements. As Matt mentioned, Truth in Savings Act, there's FINRA communications rules. Best practices require accurate disclosure. In reality, if you have a bank that has a registered structured notes program and a CD program, that CD program is going to look, documentation is going to look a lot like the registered program. They're not going to give one group of investors something less than the other. I mean, it'll be pretty close. Usually there's a disclosure statement. I'll just back up and say one thing here is that there's sort of a spectrum. If you have a fixed and floating rate institutional CD program that may have 0 to few documents versus if you start bringing in retail investors and structured notes, you need more documentation because ultimately there's a, practically, and there's a fear that if something goes wrong and plaintiffs' lawyers start working their way up the chain, you're going to want some documentation, particularly with indemnification in it. So the disclosure statement contains general disclosure really regarding the bank and the features of the CDs. Individual issuances will have individual term sheets, particularly structured ones, explaining how the CDs work. Estimated initial value. This obviously came in more than 10 years ago. SEC sweep letter, its CDs weren't subject to it, but however, as a matter of good disclosure, banks include it. Again, that's consistency between platforms. They're not going to give EIB disclosure to their note holders, and not give it to the CD purchasers. And a lot of distributors request it. Next slide. And there's some SEC guidance that's available at that link. And next slide, please. as I mentioned, you have something like a distribution agreement, program agreement, but tailored for the bank regulatory structure. Issuing a paying agency agreement with a third party paying agent, although the bank many times has an affiliate that will do that. There's a master certificate with DTC represents the CDs, a letter of representation with a CD writer, and there may be agreements with hedging counterparties. And now back to Matt for brokered deposits.
Thank you, Brad. So we need to go back a few decades here to the late 80s when the savings and loan crisis was gripping the nation. And in response to some of the practices from that, Congress enacted a new provision in the Federal Deposit Insurance Act relating to brokered deposits. And this was premised on the belief that brokered deposits were not sticky, they're hot money that can move quickly among banks. If there's a run on the banks, that it may take me a while to drive down and take out my checking account and move all my direct deposits and stuff like that. But if I just have a CD that I'm parking money in for yield or insurance coverage or something like that, I'll just move that CD over to a new bank. And also it's because of the nature of broker deposits going through an intermediary who typically is trying to get the best deal for the customer. If another bank offers a better rate, well, then those deposits will also get pulled. And so all of those are reasons why the banking agencies have asserted that brokered deposits are considered less sticky, and that reliance on brokered deposits would prompt concerns in a downturn that a bank could quickly see a dissipation of its deposit base. Slide. Because of this perception, historically, there were some constraints on brokered deposits. And I'll say that many of these constraints are less important than they once were because they're tied to the level of capitalization of banks. And back in the late 80s, the capitalization of banks was a real problem or a real issue for many banks. That there were banks that were operating that were not well capitalized. There were large banks. There were a large number of banks that had not well capitalized status. In today's market, most banks are well capitalized. There are banks that may not be well managed, but the management ratings don't figure into the broker deposit. The broker deposits look at well capitalized status. And so there are just fewer banks out there who will not be well capitalized and therefore will be subject to restrictions on broker deposits. And those restrictions are that a bank that is less than well capitalized may not be able to issue brokered deposits under certain circumstances, and it may not be able to issue brokered deposits at certain rates. These rates are defined with respect to regional and national interest rates. And the idea here is that if a bank is teetering on the edge of insolvency, it may be motivated to offer a very high interest rate to get more deposits from customers, and that would just increase the risk to the financial system and increase the risk to the customers. So we're going to prohibit the banks prohibit the banks on the edge of or in capital problem world from paying higher rates. Like I said, I'd say the 90% of banks today are well capitalized. So this really is not the same kind of restriction that it used to be, because if you are a well-capitalized bank, then none of these restrictions apply. And you can issue as many brokered deposits as you want, subject to some of the things we'll talk about on the later slides, and you can pay whatever interest rate you would like on those brokered deposits. And so being well-capitalized gets you out of a lot of these restrictions. There are some economic consequences from issuing brokered deposits, though. That one is that banks pay deposit insurance assessment rates. They're on an annual basis to the FDIC. It's akin to a premium for deposit insurance. And if they have an excess amount or a significant position in brokered deposits, that can increase the rate they have to pay. That this is a relatively complicated formula. It's not a strict percentage or dollar value or something. We can say if you go over X billion or X percentage, then you will pay an additional $500,000 in deposit insurance. It's not that easy, but it can be a disincentive if you are trying to price out the rates and you find that you're going to be paying more in deposit insurance and the rate you're paying on the broker deposits is higher than some of your other deposit options. Well, then maybe that's a problem for a bank that is looking to offer a broker deposit product. Slide. Now, the other one is for the largest banks, they are subject to the liquidity coverage ratio requirement, which is a creature of the Dodd-Frank Act around that looked at some of the concerns of banks that were well capitalized. They had plenty of capital cushion on their balance sheet, but they didn't have the financial resources to pay obligations as they came due in a crisis. That customers maybe had call rights, customers had acceleration rights, customers had cross default rights, those kind of things. And so those customers invoked commitments, they invoked contingent lines of credit, and the banks had to pay out this money. But because of the freeze up in the markets due to the 2008 financial crisis, they weren't able to access that liquidity. And so the largest banks since around 2014, 2015 have been subject to the LCR ratio. And the LCR ratio treats brokered deposits fairly punitively, that there's a default, there's the LCR is based on having enough cash to pay, or enough highly liquid assets to pay your projected cash outflows over a hypothetical 30-day period. And the outflow rate of what your projected outflows will be over that 30-day period, it varies. It's whether a deposit is retail or wholesale, whether the deposit is brokered, if it qualifies as a reciprocal brokered deposit, a brokered sweep deposit, or another type of brokered deposit. That there are different thoughts of, well, if it's a reciprocal brokered deposit, that means that one bank has exchanged deposits with another bank. Those will be somewhat stickier than a bare brokered deposit that has no offsetting deposit at another bank. Brokered sweep deposits are similarly considered a more risky product in that regard. And then also just there's the whole retail versus wholesale distinction, that while a broker deposit status doesn't matter based really on retail or wholesale, the regulators assign a more punitive outflow assumption to wholesale brokered deposits than retail brokered deposits. And so the outflow percentage will typically be higher on a wholesale brokered deposit product. Slide. And on this slide here, we have some of the hypothetical percentages, and it shows that if you have the least favored type of brokered deposit, let's say a corporate brokered deposit, a brokered deposit issued to a corporate customer that is not through a sweep arrangement, not through a reciprocal arrangement, and it has no maturity, or it matures within a 30-day window, so a short-term assumption. That's, you're going to assume, has 100% outflow rate, and so you will need a significant amount of highly liquid assets. In contrast, if you have a true retail deposit, not even necessarily a brokered deposit, but a true retail deposit, you can get down to as low as 3 or 10%. And even I think some retail brokered deposits can get down that low. So this shows the importance of structuring programs, of in some cases having multiple programs, so that you can clearly define, well, this is my brokered sweep deposit program, it gets this LCR outflow rate. This is my institutional brokered deposit program, it's at 100%, let's say. This is my retail brokered deposit program, it's at 10 or 25%. And that kind of separation is something that we've worked with a number of clients on, so that they can ensure favorable LCR treatment. Next slide. Now, one of the concerns to come out of the 2008 financial crisis was the use of brokered deposits. And there was a study conducted by the FDIC on whether it really increased the risk of bank failure. They concluded it did. again, for all the reasons I talked about on the first slide of being hot money. And so in the FDIC's world or view, some of the concerns of the savings and loan era had been fixed, but some remained after the 2008 financial crisis. Slide. And so stepping back, the FDIC recently revised its definitions for what is a brokered deposit. And it's a two-part definition. It starts off by referring to a deposit broker. And so a brokered deposit is any deposit that is obtained through or from or with the assistance of a deposit broker. This idea of a deposit broker, it's not a formalistic thing of, oh, well, they must have on their business card they are a deposit broker, that it can include affiliates. It can include the broker dealers we were talking about earlier on in the presentation. It can include people who do not have a relationship with the bank. That if the bank is just selling these CDs to someone and there's no deposit brokerage agreement, but the bank knows the person is turning around and selling the CDs into the market, that person is still a deposit broker. And so, next slide. So it's a very broad definition. There are several exclusions from it. The bank itself is excluded. So when the bank solicits customers, obviously that is not a brokered deposit. An employee of the bank is excluded with respect to funds placed at the bank. This can be an issue where you have dual-hatted employees who may be W-2 employees of, say, a shared services company, of an investment advisor, but they also do work for the bank. And if they are placing funds at the bank, that can create some complexities because the exclusion is limited to people who work solely for the bank. And we've advised people on how to treat that. So there are some relatively sophisticated tracking systems for large banks that have employees sitting in different legal entities. Next slide. Many of the other exemptions from deposit broker status are not going to be relevant to the people on this call, but the last one of an agent or nominee whose primary purpose is not the placement of funds with the bank, that is going to be the focus of the rest of my part of this presentation. And we call this the primary purpose exemption, because it has had multiple interpretations by the FDIC, and it is the one that has the greatest flexibility of arguing that something does not have the primary purpose of placing deposits. Slide. So in the 2020 rulemaking, there were a few additional exemptions unrelated to primary purpose that were grafted on really at the last moment. And in the FDIC, it was, I think, like maybe even been the day before they finalized the rule, added an exemption if someone is a deposit broker only with respect to one bank. It says, well, that is not, we're not going to include those people within the scope of brokered deposits. For some of the shared services arrangements I was talking about, this is great, because if you have a shared services company that has employees and they place deposits only at their one affiliated bank, well, then good, they qualify for this exemption. The other one is saying that there needs to be a business relationship with the depositor on whose behalf the deposit is being placed. This is typically going to be met in the circumstances of our structured CD programs, because there will be a customer of the broker dealer. This is more talking, the point of this one is more to pick up things like listing services or other people who maybe didn't establish a relationship with the depositor. The 2020 rulemaking also expanded the primary purpose exception by adding 14 types of designated businesses that were deemed to have a primary purpose other than placing deposits. A lot of this codified FDIC staff interpretations. It also added some formality to it around things like assessing the size of a business line. Some of the exemptions require a person to notify the FDIC and provide quarterly reports. Things like some of the brokered sweep arrangements fall into that bucket. And also the FDIC after that night before edit has kind of now pivoted and is tightening up on some of these broker deposit requirements. And so they now do expect banks to have an awareness of whether persons are eligible for an exemption. So it's a criticism of banks that did not consider whether certain third-party vendors were deposit brokers because there were other people in the arrangement who qualified for an exception. And we can talk about that. It's a fairly nuanced and edge case for, again, a lot of the people on this call are for the brokered CD market, which typically is not exempt from the brokered deposit status. Some of the structured CDs, we may be able to find ways to get them to be exempt, but brokered CDs, unfortunately, can't qualify for an exception. Slide. So moving from brokered deposits, there's the FDIC's advertising rules. And these have been the focus in recent years because of the cryptocurrency sector, that the FDIC has been concerned with cryptocurrency companies asserting that customer money was insured because the cryptocurrency company put it with a bank. Therefore, the FDIC built out a huge set of rules around what is a misrepresentation of deposit insurance. And the one that affects the brokered CD market is that it says that it is a material omission if a person, say a deposit broker, represents that a product is insured by the FDIC but does not identify the bank at which the product is held. So if a person puts up a billboard saying insured CDs available 5% interest rate, the FDIC would probably argue that that was misleading because it doesn't say First National Bank insured CDs available, or even a little footnote saying CDs offered through First National Bank, that the FDIC wants there to be some linkage to show that it is not the deposit broker who is insured. It's not the deposit broker who's providing the protection. It is the bank at which the deposit is being held that has the protection. Slide.
Okay.
And with that, I'll turn it back over to Brad to close out.
Thanks, Matt. Okay, last point. Finra has put out a notice. It is notice 0269, over 20 years old, on brokered CDs, but it is helpful and it just covers, I'll just discuss it briefly, what FINRA members should be concerned about when offering them. It interestingly goes through the Gary Plastics type factors to make sure people, brokers are aware they're not doing something that might cause the CD to become a security. Talks about training obligations, appropriate disclosures and sales practices, giving customers written materials that describe the characteristics and risks of purchasing brokered CDs, and it also suggests disclosures for account statements. Next slide, please. And with that, both Matt and I thank you for attending today, and we very much appreciate it. So thank you very much for joining us today.